He sounded like he was on the fence on that. I always enjoy Senator Booker's remarks. He is a dear friend, and his remarks always give me hope and confidence in America. Thanks to both of you for being here and for your willingness to serve and to be considered for these positions. I've got questions for both of you. Let's start with you, Ms. Desai. In December of 2018, you submitted an amicus brief before the Supreme Court of the state of Arizona, a state where I happen to have been born. The case was called Brush and Nib Studio versus City of Phoenix. The amicus brief that you submitted was on behalf of the national organization known as Americans United for the Separation of Church and State. In this brief, you argued that it would be a problem to extend an exemption on the grounds of religious freedom to a particular small business, an exemption to an otherwise applicable state law, and that they should have to comply with that state law, even if forcing them to comply with that state law would require the company to violate sincerely held religious beliefs. Specifically, you made the argument in your amicus brief, I've got a copy of it right here, that, quote, the Establishment Clause does not permit religious exemptions that, instead of protecting religious institutions' internal exercise of their beliefs, substantially burden third parties who do not share those beliefs. What Supreme Court precedent do you rely on, or what principle of law are you incorporating when you make this argument?
Thank you, Senator, for that question. In that case, I filed an amicus brief, and I believe was co-counsel with Americans United, and we represented a group of religious organizations and religious affiliated organizations that were in turn interested in ensuring the protection of their religious liberties. The arguments that we made on behalf of our clients in that amicus brief had to do with the balance of the Establishment Clause and the free exercise of religion. As I think you noted, the argument was that the facially neutral and generally applicable ordinance, if a broad exception was granted, could in turn raise concerns on the other side.
Right. I understand that. And your argument was that this was a problem, that it would be a problem under the Establishment Clause. And you said that it was a problem under the Establishment Clause because it might substantially burden third parties who don't share those beliefs. I'm asking you from what you derive that argument. It's a line of reasoning that I'm not entirely familiar with. Now, you cite the 1963 landmark decision in Sherbert v. Verner as support for it. Your pinpoint cite to page 409 of that opinion seems to be the source of authority that you rely on. I don't see that from Sherbert v. Verner. So enlighten me as to where I'm wrong in believing Sherbert v. Verner does not support your proposition.
Senator, I cannot, as I sit here before you, recall the citation that you reference. What I can tell you generally from my recollection was that the argument made was that if an exception to the facially neutral and generally applicable anti-discrimination law in turn could burden third parties, that might raise questions or concerns under the Establishment Clause. But I will also note that there have been a number of cases that have been decided by the Supreme Court of the United States on the topic of religious liberty, such as Tandon v. Newsom. And if I'm so fortunate to be confirmed to the court, I would faithfully and fully apply the precedent of the United States Supreme Court and the Ninth Circuit.
Okay, I appreciate that. It does cause me some concern because the source of authority is one you can't identify, I believe, because it doesn't exist. I'd love to be proven wrong. If you can prove me wrong on that after the fact, I would love to read that. Judge Pryor,